All right, this is case number 19-180-805. This is West Michigan Debt Collections Incorporated versus Brian Foster. The matter is before the court settled for a subpoena. The court did issue a subpoena in this matter set on strike that it was signed on the 29th of April 2022, setting today as a hearing date on the subpoena at 9:30 a.m. Your appearance for the plaintiff in this matter? Do I have counsel for West Michigan Debt Collections Incorporated? I have Brian Foster on the Zoom. If you're on the Zoom, please say something at this time. All right, very well. The court reviewed the call on this matter at the end of the court's call. The court now calls case number 21-171166. This is Roseville 1 LP versus Lisa Starkey or Stark. The matter is before the court settled for a motion for summary disposition on today's date. One moment here. I did in fact receive an answer to the complaint. That answer was filed on or about the 24th of March of 2022. And this statement on the answer was simply I'm on a fixed income and disabled. All right, your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Brian Narlock, P number 83990, appearing today on behalf of plaintiff.
All right, thank you, Mr. Narlock. Good morning to you, sir. And I'm looking now for Ms. Stark, is it? If you're here, say something and tell me your name.
Yes, Lisa Stark.
All right, thank you, Ms. Stark, and good morning to you as well, ma'am. I did, as you heard me earlier say, receive your answer in this matter. Your answer doesn't really seem to contest anything. It just says that you're on a fixed income and that you're disabled at this time. Is that correct, ma'am?
Yes. Also, I just had a stroke last Saturday, and I also, like I said, but with all my bills that I have coming in, I don't have enough income for those. But other than that, I don't have the income right now.
All right, man. All right, and let me ask you, Ms. Stark, you don't have a guardian or anything like that. Nobody is appointed by the court to oversee you or your affairs, anything, true?
No.
Okay. All right, counsel, I see that you filed your motion here. And basically it looks like to me, I read this some time ago, that you're claiming that there's no genuine issue of material fact and that you should be granted judgment as a matter of law at this time. And a part of that is that you're claiming that there's a breach of contract arising out of the relationship that was had in regard to a rental and a renewal relative to rental property. Looks like this is talking about some property in Roseville. Tell me what's going on here, sir.
Yeah, so this is for rental, looks like unpaid rents and utilities with regards to some property damages that resulted from a rental tenancy between my client and Ms. Stark. The amounts, looks like she moved out, I believe, on or around the end of August. She had unpaid rents and utilities, and again, damages that stemmed from July through the end of the term of the lease, which was in November. The apartment was re-rented, so she was credited back for those amounts. So the remaining amounts that are due left and owing are the $3,872.81.
And what was the rental rate, if you recall, counsel?
It was $970 a month.
Do you know if that rent was supplemented in the process at the time?
I don't believe so.
right, so Mr. Art, it seems that the motion that's brought is setting forth that you left your rental arrangement early, and that of course, under the agreement, the rent continued to approve, and that as a result of that, as well as a claim that there were some things that were left in repair or that were damaged, that has resulted in a indebtedness in the nature of $3,800. And so there's been a motion filed that says that, Judge, there's no genuine issue of dispute that there was a breach of contract here. And so, Judge, give us a order determining that this case, that the plaintiff wins in this case because they brought this action and there was a breach and there's really not a defense to it. Anything you wanted to say to me? Go ahead, man.
The breach was that my dad and I stayed there together. My dad passed away April of that year. I stayed there as long as I could, but I didn't have any because I retired on duty disability and I was only getting my pension, and which wasn't enough. And I was waiting for my disability to come through. So it didn't come through until November of that year. So therefore I had to move out. But there was not any damages done to the home. They were charging me for things that I left behind, like curtain rod, shower rod that I didn't take down, stuff like that. But other than that, that was why I was breached. Otherwise, I would have still been there, but I didn't have the money to stay there by myself. Had my father and I passed away.
So you can see that the rent was some $950 a month, correct, ma'am? Or
Yeah,
and the agreement that existed at the property, that was an agreement that had your father's name on it as well as yourself. Both of you signed the agreement. Is that true?
no, it didn't have my father's name on it, but he stayed there with me.
Oh, okay. So you rented it and he was staying with you, correct?
Yeah, but we split, all the bills, utilities, excuse me.
Yeah, I understand. I understand. And so has the stroke affected your speaking ability? Some is that part of the problem?
Yes, my speech and my whole right side.
All right, I've listened to the argument on the motion for summary disposition, and certainly as it relates to the issues that are raised in this case, there is not really a defense to the claims asserted. Therefore, plaintiff is entitled to a grant of a motion for summary disposition regarding this matter as to all issues, except perhaps on the issue of the amount of judgment. But certainly the plaintiff is able to proceed by way of a court granting the motion for summary disposition on the issues that are raised in this case. The challenge here is that counsel indicated that there were some issues that were set forth as damages to the property. Certainly, the exit from the property and the reason taking reasonable steps to re-rent the property, and whether or not there was additional rent. And if you leave and you're under a contract, additional rent can be charged. The part that I'm concerned about is the part that says damages to the premises in this matter. Counsel, what is being claimed, or how much of this indebtedness is being apportioned to claims that there was damage to the property?
I am showing. I know that she did mention the curtain rod issue, so that was a $35 charge. They had to replace one of the shower curtain rods, which was a $29 charge. There was some stuff that was left over, which the defendant also admits that were in the unit, which was a $36 charge, which were various items such as it looks like a kitchen chair, tire recliners, backpacks, just various stuff that was left in the house or in the apartment. It looks like there was some excessive wear and tear to the carpet for a charge of $146. A large bleach stain in the master bedroom, some other various stains that needed to be cleaned. Looks like there were 5 keys issued, only 1 returned. So she was charged $100 for the remaining keys. And then I believe there was just a couple other missing items for small miscellaneous charges, a $10 charge for a light cover, a $20 charge for a molding that was needed to be repaired, and then also a $35 charge for looks like a wall guard next to the stove that was burnt. So not a whole lot of excessive charges here. It looks like they're only about $300 of damages here, which the defendant has admitted to the majority of them, as she indicated. And that can be found in Exhibit 2.
All right, and so after the defendant vacated the property, he also continued to assess the late fee for the months that she had already vacated the property. Is that correct? Looks like
That is correct, yes.
At the time that she left the property, council, it seems to be, at least in looking at this, that she did in fact turn the key in that she had and gave notice that she was no longer in the property, correct?
There should be a credit amount on the last page of Exhibit 3, which she was credited back for. I don't see that she was given credit back for that $100.
And there was and while you look at it, there was in fact a security deposit that you did credit the security deposit balance. That was some $420, correct, sir?
That is correct.
All right, so the court has granted the motion for summary disposition regarding this matter. As to the damages that have been alleged in regard to this matter, they're set at $3,872 plus various costs that's allowed by the court. I'm going to reduce the amount of the damages based upon some of the calculations that were made throughout the summary. So judgment will enter for the judgment will enter for $3,500, and with the court costs in this matter, $115 plus $175. The combination of those 3 amounts will constitute the judgment that will be entered in this matter. And so the judgment will enter for $3,685, $3,690. Judgment, the court will grant a judgment in that amount. It is so ordered at this time. You receive a copy of this document. As relates, ma'am, to the fact that you are unable to pay and you have disability issues, you will want to raise that by filing perhaps a motion for partial payments or any challenge that you have if there are efforts to collect against you and you want to file something with the court. You can certainly file a petition asking the court to look at your resources to determine whether or not certain actions can be taken against any assets that you have. But that's the best that can be done at this point. We have to wait on that next step. You can always file for partial payment. That kind of prevents wage garnishment types of things. But again, I understand that this is an issue where you are under economic distress at this time. So if there is an effort to collect against you, then you want to bring that issue before the court at that time that you're under economic distress, so that the court take a look at it. It's premature to deal with that at this point. All right, so the judgment is as I've indicated. I will make sure that copies get out right away. I do wish you well, Ms. Starks. Thank you, Council. Good day to the two of you.
Thank you both. Have a good rest of your day, both of you.
Thank you.
a moment. if you want. Let's see. Judgment has been entered. Now I need to mail out. This is the file. You need it, Rich. All right, the court now calls case number 21-162-798. This is Metro Med Pain Management versus City of Detroit. The matter is before the court. I believe this is adjourned date for a motion hearing on this matter. Your appearance for the plaintiff at this time, please.
Joe DeCruz on behalf of the plaintiff, Your Honor.
All right, thank you, Mr. Zakura. Your P number for the record, if you will, sir.
P84445.
All right, thank you, sir. And, good morning to you. Looking for someone from the city of Detroit at this time. You on the Zoom, say something. So, Mr. Zakura, tell me, update me, tell me what's going on here, if you know.
Your Honor, I don't know. I don't see a motion in our file. And if there is, I don't have it. But at this time, if this is the date and time set for a motion, then we'd ask that you deny their motion because they didn't show up.
And I've got a couple little notes that I have here, but I also have case resolved.
Oh, I don't see it. I don't see that as resolved either. It could be wrong.
That's a note from 4/28/22. Defendant appeared and believes the case is resolved. You were not here at that particular hearing. And when they appeared, they indicated to the court, they believed that the case was resolved. And I set this date as a control date. Come back and take another look at things.
I do not show, Your Honor, that this was resolved. So it would be news to me. I could be wrong, Your Honor. It wouldn't be the first time. Certainly will not be the last time. But I don't think I don't have anything that shows nothing in the system, nothing in my emails, nothing that shows that it's resolved.
So why don't I give it another date, and if you will, Counsel, I know that you're quite busy, but if you could corral the other side on this, I know that you deal with with the city on a regular basis. We'll send out a notice, but if you corral them and kind of drill down on this to see which direction this is going, the next hearing would be more fruitful than perhaps today.
I will do that, Your Honor. What date would you like us to appear? And I'll let sister counsel know.
That's going to be the 6th of July. We'll go ahead and put it over to the end. Unless you want to come back sooner than that, I can bring it back sooner.
The 6th of July is fine, Your Honor.
So 7/6/22, and that's going to be at 9:45.
Yes, Your Honor.
All right, and we'll get a notice out, but like I said, kind of corral this a little bit, if you will, and let's see if we can make it a little bit more fruitful the next time.
Yes, Your Honor. I will make a note of it right now to notify sister counsel. And you said it was at 9:45 again, Your Honor?
That's correct.
Okay, Your Honor. I'll make a note and I'll reach out to sister counsel and let her know.
Thank you, Counsel.
Thank
I'll see
you.
soon.
A pleasure seeing you, Your Honor. Take care.
Always, sir. All right, again, Michigan versus Ryan Foster. If there are any persons on this Zoom regarding that particular matter, which is a suffix 0805, please say something at this time. All right, it appears that neither side appeared regarding this motion regarding, I should say, the subpoena. Therefore, the subpoena will be suspended